Good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today is Friday, April 3rd, 2026. We have 12 bills on the docket. We're going to start off with Delegate Bagnell with House Bill 1181. Welcome.
Good afternoon, Mr. Chairman, Mr. Vice Chairman, and members of the Judicial Proceedings Committee. For the record, I'm Delegate Heather Bagnell, District 33C, Anne Arundel County, here in strong support of House Bill 1181, Children in Out-of-Home Placement Voluntary Placement Agreements. I'm pleased to share that this bill comes before you with strong bipartisan support. It passed the House unanimously after receiving favorable reports from both the Appropriations and Health Committees, again with unanimous support aside from one excused member in each. The bill was also amended during the House process to clarify its scope and ensure it works as intended for families and local care teams, and it is a part of the Speaker's Pediatric Overstays, Unlicensed Settings, and Foster Care Reform package. A voluntary placement agreement, or VPA, temporarily places a child with documented developmental disabilities or severe mental illnesses in the physical but not legal custody of the Department of Human Services so they can receive out-of-home care. VPAs are often the only pathway for children in crisis to access residential treatment centers when their families cannot afford that level of care. However, families entering into a VPA are frequently unaware of the red tape and financial burden they will face just to secure the necessary care for their children. According to the Maryland Department of Health, approximately half of pediatric overstay cases across Maryland are tied to delays in the VPA process. While Medicaid typically covers the clinical cost of care, families are still required to make child support payments, often exceeding $1,000 per month to offset residential placement costs. For many families, that is simply not feasible. And when they can't keep up with those payments, they may be forced to withdraw from the process altogether, cutting off access to the very care their child needs. Even for those who do remain in the system, bureaucratic delays and challenges with interagency coordination can create significant barriers. And in the most extreme cases, families have relinquished full custody of their children out of desperation. No parent should have to make that kind of decision in order to get their child medically necessary care. When the system fails, the consequences for children can be severe. Some remain in hospital rooms for days, weeks, even months, waiting for an appropriate placement. They don't see the sun, they don't see their friends. They're not getting to go to school. As Madam Speaker noted last session, the General Assembly established a work group to study children in unlicensed settings and pediatric overstays. That work is ongoing, but the very first recommendation that they made was clear that we need to improve the VPA process. So House Bill 1181 aims to reform that process, first by clarifying eligibility, by establishing that families only need to demonstrate reasonable efforts to prevent out-of-home placement, making clear they do not have to exhaust every possible service before seeking help. Second, it creates clear and timely expectations. Local departments must schedule an assessment within 5 business days of a request and issue a written decision within 5 business days after that assessment. The bill also clarifies that local care teams may continue to pursue alternative or interim services during this process and further defines the roles of the local behavioral health authorities and care teams. Third, it removes obsolete, arbitrary, and unnecessary barriers to essential care by prohibiting referral to VPA cases to child support services and requiring the Child Support Enforcement Administration to modify any existing child support orders tied to a VPA. Fourth, it strengthens implementation and oversight by establishing annual training in coordination with the Maryland Department of Health on the administration of voluntary placement agreements. And finally, It establishes a reporting requirement on hospital discharge delays, family outcomes, reunification rates, implementation of VPA reforms, and recommendations for further statutory changes. Now, working with the Appropriations, Judiciary, and Health Committees, Maryland Department of Health, Department of Human Services, and the Governor's Office, House Bill 1181 was amended to make clear that families can still get other services while going through the process, strengthens the changes around child support by limiting enforcement and requiring updates to existing orders, clarifies who is responsible for helping connect children to treatment, and improves how the state tracks outcomes and accountability. Again, this bill passed the Appropriations Committee unanimously. It passed the Health Committee unanimously. It passed the House unanimously. It won't solve every challenge in behavioral health access, but it is a meaningful and bipartisan step and multi-agency step forward. It makes the process clearer, faster, more workable for families trying to get their children the care they need. Now, given a concern that was raised about a potential conflict with Title 4E of the Adoption Services and Child Welfare Act of 1980, we are working on an amendment to address the issue and ensure that we are not out of compliance, while also preventing additional delays to implementation. This is a priority of our Speaker, and it is a priority of our state. And for all these reasons, I respectfully ask for a favorable report on House Bill 1181.
Thank you very much, Delegate, for the presentation. Questions from the committee? Senator James.
Thank you, Delegate, for a very concise and clear presentation. I'm just not as familiar with this category of children, even though when I was on Appropriations in the House, I chaired the Health and Human Resources Committee. So just in a non-technical speak, what is it? The nature of these children are that they have often profound disabilities or mental challenges for which the family is not equipped or financially or otherwise to handle. So they seek help from the state, and they want to place their child in what you might call an out-of-home placement to get that care. Mm-hmm. That's the
That's exactly
okay.
Right.
So then. So that's what they do, and then currently, in real layman speak, what has been happening and what does this bill, very briefly, try to address?
Sure.
I understand the technical, so I'm just trying to understand the very core thing you're
Absolutely.
doing.
So there has been a broad interpretation of the existing statute. The statute spoke to exhausting all resources. And we've been working for a number of years.
Before the child could then
qualify
for some.
Yes, okay. to qualify for this higher level of care.
Got it.
And we've been working on bringing our community and home-based wraparound services online for a number of years. We actually did a big reform on that waiver. But that is just coming online when we went to a waiver. The eligibility for that program became so high that we went from serving 300 kids a year to about 35. We've been working on those reforms. That's about to come online. But because there are still these other services and other waivers, there was not clarity that you could pursue them simultaneous, and that the local care teams could also be looking at other services while in the process of eligibility for VPA. So there's just been multiple layers, and they couldn't work simultaneous. And there also wasn't a clear timeline as to when they had to make an eligibility determination, and there wasn't clarity for the families as to what their burden and responsibility was when they entered the process.
And either in current or under your revised process, does the parent then give up, is it?
Parental rights? No, they would not.
They don't.
They would retain rights. They're just giving up physical rights for the term of placement. But what has been happening is that when parents are, they can't get the services they need. They've actually been giving up their parental rights because then their children become a burden of the state, and the state is required to provide these services, which is a terrible, terrible place to put parents in.
So this would
It's
allow
not that
them
they
to
don't
retain
want to
their
give the care.
custody of their child, but get the same level of care.
Exactly right.
And then I guess for whatever reason, the fiscal note is not high.
It's not.
So
It's not because, again, it's
Because
just
one way or the
streamlining
other.
an existing process.
And the reason I ask you a lot of these questions is I grew up, one of my best childhood friends, she's still a dear friend of mine, a younger sister, profoundly disabled, profoundly, and remarkably is still alive when that was not supposed to happen. So we're talking about in her 50s. And then the parents have always, God knows how they did this, took care of this child at home, even though the mother was a nurse and the father had an outside job. I don't know how they ever did it, but I remember Carol, that was my friend's younger sister, always in the living room with us and with us. Now, as they're aging, they're deeply worried about getting help without having to give up their child to the state. They don't want to give their child up to the state, but they're also in their 80s now, and they desperately need help. And it sounds like this might, in some fashion, be a start to helping even someone like that, if that's the choice they
Well, and this is speaking to adolescents, but yes, if this process had been available to them, this streamlined process,
But
that,
this is only for children.
yeah, this is for adolescents.
I got you. Well, that's another problem we've got too. All right, thank you, Mr. Chairman.
Thank you very much, Senator. Further questions for the delegate? All right, thank you very much.
Thank you very much.
Thanks. With that, that'll conclude the hearing for House Bill 1181. We'll now move on to Delegate Smith with House Bill 1258.
Thank you, Mr. Chair and distinguished members of the committee. For the record, I'm Delegate Stephanie Smith, here to present House Bill 1258. House Bill 1258 is fundamentally a child safety and consumer protection bill that addresses a growing gap between Maryland child welfare licensing laws and the modern online marketplace. Today, Maryland families increasingly turn to the internet when exploring adoption services. Unfortunately, online advertisements often blur the lines between licensed child placement agencies, attorneys, and unlicensed intermediaries. For prospective adoptive parents and expectant parents facing difficult decisions, it can be nearly impossible to determine who is operating legally and who is not. HB 1258 creates a clear rule in Maryland that no one may advertise adoption placement services unless they are a local Department of Social Services or a licensed child placement agency authorized under Maryland law. Adoption placement is not a typical commercial marketplace. It involves children, permanent legal custody, and other legally complex circumstances. Maryland already requires licensing for child placement agencies to ensure oversight, accountability, and compliance with our child welfare standards. HB 1258 simply ensures that the advertising marketplace reflects that same regulatory intent. Nationally, child welfare policy experts have raised concerns about unlicensed intermediaries who advertise online and facilitate placements with limited transparency and accountability. Even in states with restrictions, enforcement gaps have allowed improper advertising to continue. When the front door to adoption services is an unregulated online marketplace, families may unknowingly engage with actors who are not subject to Maryland oversight. HB 1258 mirrors proven policy approaches adopted across the country. 33 states prohibit unlicensed entities from advertising adoption services. Additionally, 22 states specifically restrict advertising to in-state licensed entities. These states have recognized that regulating who may advertise is an essential component of regulating who may place children for adoption. This bill authorizes authorizes the Department of Human Services to refer violations to the Attorney General and empowers the Attorney General to pursue damages. We worked with the Attorney General for the amended version that's before you to show that a violation of this act would be deemed a violation of the Deceptive Trade Practices article under the Maryland Consumer Protection Act. So without a clear statutory prohibition, Maryland risks becoming a digital marketplace where unregulated actors can target families and vulnerable parents. HB 1258 is a preventative policy. It closes a gap before the harm occurs. It reinforces public trust and keeps adoption placements with Maryland's regulated child welfare system. I'm happy to say that this bill passed out of judiciary unanimously and passed out of the House floor 131-4. And for those reasons, I respectfully urge a favorable report of House Bill 1258. Hello.
Thank you, Delegate. Thank you for bringing. Does this have any impact on existing adoption practices? And what I mean by parents, grandparents, attorneys acting in the normal legal pouch?
No, not at all. This is about the advertisements from unlicensed entities. We've had some scenarios where an example that was given in the House hearing was someone arranged for adoption out of state with an agency that was not licensed in Maryland. Unfortunately, the spouse, they were estranged, was unaware that this child was brought. And we have rules regulating that type of transparency and notification that the other state that the agency was based in didn't. So this created ultimately hardship not only for the father reconnecting with his rights and access to his child, and the heartbreak for the family that invested money trying to build a family. And we want to prevent any of those types of tragedies from happening moving forward. Yes, sir.
Hi, Delegate.
Hi,
Good to see you again. I just was reading the joint submission of the Maryland adoption attorneys. And before I read that, I was having those same concerns. I get the goal, but there are adoption agencies that I think would, should be able to advertise whether they neatly fit in under your bill. So did you address their concerns about, the constitutionality of how broad your bill is, maybe restricting some attorneys and things like that, also disrupting the additional pathways you have to adopt? In other words,
Yes.
you can adopt a child without being a
without-
state agency.
completely.
And I'm not sure about being licensed. Let's say
Right.
I have a great adoption service in Wisconsin. I can go to Wisconsin, and adopt a child. Blah, blah. So how did you amend the bill to address that? And are
think
we
that-
all
yes.
copacetic now?
Those concerns, I think, are not relevant to the underlying bill. This bill is about advertising. So you could still engage in other private, contractual agreements related to adoption, but what that Wisconsin agency that's not licensed in Maryland can't do is advertise in Maryland.
Now, why would that be if everything else they're doing is entirely
Well,
lawful?
I just think that many businesses that operate in a multi-state or national manner understand that they have to meet the state-based legal expectations of doing business there. So this would just create a floor for doing business in Maryland that should those businesses want to have Maryland as part of their consumer base, they would simply meet the state's expectations, just like any business meets whatever state's expectations
So
are.
in other words, the Wisconsin business, if I wanted to go to Wisconsin and adopt a child, that's
Yes.
fine. But if they wanted to,
Advertise.
well, not advertise, but they wanted to help me adopt a child in Maryland.
Correct.
Then they would have to be compliant.
This is an
before the-
advertising bill.
Let me finish. Before, I understand that.
Yeah.
Before they advertise, because the bill
Yes.
is that is about advertisement, but it also has a mandate that you be licensed.
Yes.
In order to advertise
Correct.
in the state.
Correct.
And so I don't know if I know you work with the Attorney General, I appreciate that. I don't know whether you have some letter where the Attorney General also agrees that whatever you've amended the bill would address the adoption attorneys.
No, because
Pretty
it's
lengthy
not.
document.
Yeah, I appreciate
yeah.
their communication, but it's not speaking to the merits of the underlying bill.
All right.
So
Well,
I
I'll take a-
appreciate their
right,
input.
well, I'll
But the
take a
AG's office was a clear partner every step of the way of amending this bill and did not highlight the inconsistencies raised there.
Do you have anything from the Attorney General that we could look?
Just the amendment, because it's coming from them.
Okay, well, okay, maybe they would send something over to us.
I would be happy to follow up.
Oh, that would be great. All right, thank you, Mr. Chairman.
Yes.
They do have a letter in the bill file,
Original,
but that was
Yeah.
before the amendment was
Yeah,
offered.
but not a new one, I meant.
Yeah,
I was looking for something up.
updated, yeah.
Yeah.
Senator Sidnor, are you next, or you good? All right. Further questions from the committee? All right. Delegate Smith, thank you.
Thank you so much.
All right, with that, that'll conclude the hearing for House Bill 1258. We're now going on to Delegate Embry with House Bill 1105.
Thank you, Chair. And is it all right if the members have signed up in support? Thank you. And I promise this is my last time here this session. I know you're probably sick of me. This bill is also familiar. Hopefully, it passed out of the House again this year, near unanimously. I think there was one vote in the negative in the committee and in the House on the floor. And the purpose of this bill, as you may recall, is to allow local jurisdictions that have consumer protection statutes and lawyers who do the work, allowing them, instead of the default 1 year, 3 years statute of limitations. And I'm going to focus on three aspects and just try to cut to the chase in terms of what's really in dispute, you'll hear from opposition about. I want to focus first on the fact that as important as this was last year, it's even more important this year. The federal CFPB has been gutted. It is effectively a zombie regulatory agency, as its former general counsel has described it. So the work at the federal level is just not happening in terms of protecting consumers. It's gutted not just in terms of personnel, but in terms of what they're allowed to pursue. So it's even more important that our local jurisdictions are empowered to do the work. The Attorney General does great work, but there's a lot of violations. We have every week we learn about a new fintech product that is unregulated, untested, and so the work of our attorneys is really important. Number two, we did make a change in the House. We hope that will alleviate some of the concerns. This is civil only. There's no criminal aspect. The statute of limitations for a criminal act would be the same, civil only. And then the third issue, which is still the remaining point of contention, is what triggers the 3 years. And so the rule that we have adopted, the discovery rule we have adopted, is when the government knew or reasonably should have known. And the reason we selected that is the rule for private tort actions in the state of Maryland. So if this action, the same action were brought by a private entity, that would be the applicable rule. It is less onerous than the federal rule. The federal rule is just when they knew. It's not even reasonably should have known. So for federal actions, it's a more favorable rule for the government, less favorable for the people being investigated. And finally, the state attorney general has no statute of limitations for their consumer protection actions. So we believe this is the appropriate rule. It's fair, knew or reasonably should have known. These are consumer protection violations, deceptive practices. Often they are unknown until something happens. It could be a hidden fee that is not disclosed until, property is sold, or someone tries to activate their warranty and they realize, oh, in fact, this awful thing was hidden. So it's really important. What the opponents want is that it's from the date of the violation, but that is really would be hamstringing the regulators, because the violation could be hidden indefinitely, and in fact incentivizes the regulated or the entity that's violating the law to keep it hidden, because they just have to keep it hidden for 3 years and then they're good. So reasonably should have known is a protection. It means that the government can't just sit on its hands. If there were things that they could have discovered because they were visible or were easily discovered, then that would count against them if they brought this action after 3 years. So for all those reasons, I think this bill is really critical, always, especially now. Baltimore City is here because they've done a lot of affirmative litigation in recent years. You've probably read about some of their successful litigation, including ghost gun manufacturers. There's a DraftKings suit, the opioid suits. I mean, a lot of amazing work. So they're here, but there are other jurisdictions that also do this work: Montgomery County, Howard County, and Prince George's County. And we've learned that other jurisdictions are also looking at expanding their work in this area. So it is a statewide issue. So with that, I would love to answer questions, but first I will, if it's all right, I'll turn it over to the witnesses. Thank you so much.
Chair Smith, members of the committee, my name is Christopher Souza. I'm a litigator with the Baltimore City's Law Department, and I'm here to speak on why the city supports HB 1105. Our local consumer protection ordinance allows the city to bring actions against businesses that engage in unfair, deceptive, and abusive trade practices. It gives the city pre-suit subpoena power so that it could conduct comprehensive investigations. Those investigations can ensure that the city directs its limited resources to focus on deliberate and systematic misconduct. It also helps the city base its cases on a strong evidentiary foundation. Recognizing that these investigations can take time, other jurisdictions like Chicago and DC do not subject their enforcers to any statute of limitations. The same goes for Maryland's administrative actions, and Maryland AG. Pennsylvania and New York enforcers have 6 years to file consumer protection actions. But in contrast, Maryland local governments like Baltimore City has only 1 year after a violation is sued. This short period has hamstrung our ability to, for example, challenge practices that exploit vulnerable gamblers or ensure that payday lenders operating in the city comply with state lending laws. The bill would simply align the statute of limitations that's already applicable, align the statute of limitations applicable to local government actions that are already applicable with that brought by private plaintiffs, 3 years from the date the plaintiff knew or should have known that a violation occurred. Businesses are already subject to this exact limitations period because of the potential for claims by private plaintiffs. So the bill, by definition, does not change any sort of obligations already imposed on Maryland businesses, record keeping or otherwise. The new or should have known language, also known as the discovery rule, is already applied in other contexts against state enforcement actions. And make no mistake, the discovery rule imposes real constraints on plaintiffs. Courts, state, federal, all kinds of courts routinely require plaintiffs filing after a delay to demonstrate that they've exercised reasonable diligence. I came to the city's law department from the Consumer Financial Protection Bureau after the Bureau's operations were basically shut down. The corporate cops on the federal level have been completely taken off of their beat. Now is the time to empower local governments to make sure that this law enforcement vacuum that has been created can be filled. So that's why I strongly urge the committee to favorably report this bill.
Excellent, thank you.
Good afternoon, Chair Smith, members of the committee, Nina Themeles, Director of Government Affairs for Mayor Scott in Baltimore City. I just want to underscore the comparative statutes of limitation and discovery rules in other states. So most states have significantly longer statutes of limitation if they oppose any at all. Nevada, Connecticut, Hawaii, Texas, Kansas, Washington, Wyoming, and Illinois have no statute of limitations on these claims, and a government action can be brought at any time. Many states also use the discovery rule, and they also have a longer statute of limitations. Those include Minnesota, New Jersey at 6 years, California, South Dakota, and West Virginia at 4 years, and Colorado and Wisconsin at 3 years. For the states that don't have the discovery rule but still have a longer statute of limitations, they impose significantly longer periods of time for the government to take those actions. So those include Michigan, Alaska, and New York at 6 years, Delaware and Arkansas at 5 years, Massachusetts, Nebraska, and North Carolina at 4 years. So what we're asking for is extremely reasonable. 3 years in a discovery rule is not outside of the scope of what most other states are doing, and also with other actions that are taken within the state of Maryland. It would not put any additional burden on businesses in the state, given that they would already have to be retaining records for other actions that could be taken. And then I just want to underscore that these are for deliberate actions, deliberately deceptive and unfair practices. This is not just general negligence. This is businesses who are knowingly violating either state law or other regulations and practices. And we are looking to protect our residents and your constituents by being able to take action versus just having an arbitrary time clock expire. So for those reasons, urge a favorable report on House Bill 1105. Thank you.
Thank you, Mr. Chair. Delegate Embry. Nice to see you.
Nice to see you.
Thank you for bringing to us a short bill which is easy to read and easy to comprehend. So my question is, doesn't the state of Maryland have a consumer protection code?
Yes.
And I assume the Attorney General is in charge of enforcing it.
Yes.
That being the case, why do we need to have local consumer protection codes independent of, and I guess more comprehensive than the state's consumer protection code?
I don't know. I would let the representative from the law department describe the ways they differ. I don't know that it's more comprehensive, but the reason is because of the volume of violations. And so the Attorney General has no objection and is grateful, I think, for having locals doing similar work. They sometimes work together. Sometimes not, they do different things, but just given the scale of issues out in the world, people who are businesses taking advantage of consumers, it's valuable to have.
Well, here's
judicial
my
work.
concern and my question. Many businesses operate beyond county borders.
Yes.
So there can be a Baltimore County business which operates in all of central Maryland, Harford County, Carroll County, Anne Arundel County, Baltimore City, et cetera. Wouldn't it be better for that business to be governed by a single consumer protection code that they and their attorneys could be familiar with and could make sure that they comply with, rather than having to comply with higgledy-piggledy consumer protection codes in one county after another, which may be different, inconsistent, redundant?
Well, I think they're, I mean, and again, I will in a second defer, but they are essentially the same. It's unfair, deceptive trade practices. So really they are, I think it is modeled. In fact, if I may.
Sorry.
Yeah.
The substance of what's prohibited by the city's ordinance is identical to state law. It incorporates the state's definition of UDAP. It's a question of,
If
sorry.
that's the case, why don't we let the Attorney General handle the enforcement with one staff, totally, rather than have each independent jurisdiction establish their own enforcement staffs? Aren't we spending a lot of money we don't need to spend because you've got different enforcement groups, I guess, vying to enforce the same code?
They're not vying. As I said, the volume of violations is so great that there is no competition over which cases to bring. And in fact, it's really not wasted money. I mean, this is not to generate money, but the affirmative litigation carried out by the city resulted in, I mean, this was not specifically consumer protection, but similar opioid settlements in the millions of dollars. So it is, in fact, again, that's not the reason, but it is money very well spent in terms of bringing dollars back to remedy the harms against the consumers of the city. But the Attorney General does not object to the existence of these units. I think, I don't want to speak for them, but I think they're grateful for the help in the absence of federal enforcement. There is no federal enforcement, which used to be the premier entity in the country which would do this work.
So last question, what is the statute of limitation that's applicable to the Attorney General and his enforcement of the state consumer protection?
They do not, they take the position that they do not have a consumer, that they, excuse me, they do not have a statute of limitations for the Consumer Protection Act.
Really, the normal, the default statute of 3 years is not applicable in these cases?
No, and they, a few years ago, brought a bill to codify that, and so I'm happy to share with you their testimony. Yes.
Interesting. Thank
But
you.
yes, not only do they take that position, they have successfully litigated it. Yes, I think that's right.
Thank you very much. First of all, thank you for the bill. I used to serve on the Consumer Protection Commission in the old AG's office, so I have no issue with locals having their own. But the question that I have, you rattled off a number of counties. I'm assuming Baltimore County isn't in there.
They may be exploring it, but they do not have a unit, as far as we know. I did ask MACO if they could give me a list, and Baltimore County was not on it in terms of timing unit. They may be considering it.
And just this hearing just kind of rejiggered my memory, because I think prior to session, I think I was intending on reaching out to your office about a parking lot who puts up signs that market one price, and then when I left, it was a different price that I had to pay. So I think your argument makes a lot of sense that you may need a little bit more time. I mean, it may just been $5 or $10 to me, but if you keep doing it to a bunch of people, it adds up to a whole lot of money. So thank you.
Thank you.
Delegate, it's good to see you. I had a little bit of a similar concern with Senator West. I'm not against consumer protection in any way, shape, or form. I'm just trying to think of the best approach here. And a couple of things come to mind. I'm certain that other states have done this, and I think the federal government does this sometimes. To me, it makes a little more sense for efficiency to have the AG be the head of all this, and certainly then delegate to the various counties consumer protection enforcement. I think where I'm with Senator West is that it's nice that right now the codes are similar, but there's no requirement that we make them aligned unless we were to codify that in some way. And I'm very sensitive to businesses saying, look, we want to comply, but 23 jurisdictions, 20 different, potentially different codes, varying statute of limitations. That's a lot to contend with, even when a business is trying to do well. So I'm not sure I'm convinced this is quite the right approach, and I've seen it in a number of other schemes where we are trying to protect consumers or the public. We have this much more coordinated effort codified, as opposed to, that's the way it is at the moment. So I throw that out to all of you to think about in terms of my having a little heartburn about this. And then, I very much, so you can answer that in a second, but let me just get the second part out before I forget it. I think I heard a lot of people say, hey, we might be out of line with the 1 year. I'm fine with that, but again, we have a state. I thought we gave the Attorney General Consumer Protection Authority, didn't we?
They do. No,
Right,
they do.
didn't we?
Yes. They
That's
have
right.
it. They just don't have a statute of limitations.
Okay, so they have no statute of limitations. I guess that's whatever we did. And then you all want to, do more of a 3, which I think is generally, a reasonable change. So that I don't have a problem with. I have more of a problem that currently we don't have any mandated alignment and sort of mandated coordination. I'm fine with you taking the burden off the Attorney General, but I like the idea that there is a one voice in Maryland as to what will and will not pass as the right way for someone to interact with the consumers. What are your thoughts on that?
No, I really appreciate the question. So as we heard, I wasn't sure if it was nearly identical or identical. It's identical. So the local ordinance is identical to the state ordinance. There is every incentive for the localities to have matching language. These are our local, or counties in our city are sovereign entities with, so they bring suits all the time based on common law.
Just with our delegation of authority. Okay.
Well, no, but with common law principls.
No, that's
we
fine, yeah.
have the power to restrict
Right.
it, but they do.
I understand.
Absence our acting, they have the power to
Right.
bring common lawsuits and other actions. So I understand your point. They are currently identical. I would certainly be open if we ever got to a point where they weren't to possibly legislating, but that is not the current situation.
Yeah, I think that would be where I'm coming from
Yeah.
a little bit, and I think if we're going to do something like this, we might as well think forwardly about all the ways in which we can make the idea better. But you're a great delegate, always bringing good bills to us, and I appreciate it.
Appreciate you.
All right.
I
thank
would
you.
encourage us to, well, I understand your point. I
Yeah.
would wait until that's a problem before legislating it, but
Yeah,
I
like to
hear
get
you.
ahead of
and
myself.
I
Yeah,
respect
thanks.
this position.
Thank you.
Thank you, Mr. Chair. Thank you, Delegate, for bringing
Thank
it.
you.
My question is for either one of the witnesses. Was wondering if you could provide maybe an example where the enforcement actions couldn't proceed under the current 1 year, but would be viable under the expanded to going to 3 years. They're going to want you to stand up. We like to see tall people.
Yeah, thank you. So, I can't speak to investigations that are non-public. We make sure our investigations stay non-public so that the individual businesses that are being investigated don't get publicity about being under investigation until we decide whether there are claims there or not. That said, I could speak to a lot of the work that the city's done. It's public about earned wage access in the state of Maryland. There's been legislation that addresses and incorporates earned wage access into the general financial structure of the state of Maryland. But there were certain aspects of our investigation were curtailed because we had such a short window to follow through on enforcing what existed at the time in Maryland, the laws against business practices that had already been discontinued. So that was one instance of others, but that's one that I could speak to.
Further questions from the committee? Question is, so you're from the city solicitor's office, and then, so that's a functional equivalent of a county attorney in the other 23 jurisdictions.
Yes.
Why could you could ask for a concurrent jurisdiction to enforce the state consumer protection law? Could you not, or could you?
I don't know do you know the answer? I don't know the answer to that question.
Because it seems like that would solve a lot of the problems for the kind of like the disparate, like 24 jurisdictions having different statutes of limitations and different schemes. I don't know. I just didn't know if there was a way, if there was a reason why I didn't approach it, if it was possible.
Yeah, we could find out and follow up.
Okay,
Yeah.
excellent. Seeing no further questions, thank you all very much. So that will conclude the testimony for the proponents of the bill. We'll now hear from the opposition panel, and we'll hear from, is Hugo here? Oh, come on up, yep. And then Grayson.
Good afternoon, Mr. Chair, members of the committee. Grayson Wiggins here on behalf of the Maryland Chamber of Commerce. So what we're asking for is to remove that telling provision about when local authorities knew or reasonably should have known. That is how the bill was originally introduced back in 2024. It also would further align the bill with the Courts and Judicial Proceedings article, where there are more than 20 instances of that statute of limitations without that telling provision. The proponents indicated that there are examples in state law with that tailing provision. Those are only, as I understand it, applicable to the critical Chesapeake Bay area of Talbot County and for funerary objects. So this would be a massive expansion of that language within the statute. I also want to note there was discussion that the city law is identical to the state law. That may be accurate. I haven't done a full analysis, but I do know that Montgomery County's is different. And Montgomery County's has specifically written housing and landlord issues into their Consumer Protection Act. And so I think that gets to the point raised by Senator James and Senator West, where this would create a situation where you have 24 potentially different laws on the books. Also, I'd ask you not to look at this bill in a vacuum. My understanding is that this committee and the House have moved a bill that have removed the cap completely from Baltimore City law related to the amount of fines that could be levied under this. That's Senate Bill 209, and that's currently moving right now, and so that would remove any cap on the civil penalties that the city could impose under their Consumer Protection Act. I'd also note in Howard County, our Howard County Chamber of Commerce spent a lot of time over the interim negotiating the current Consumer Protection Act with this county council and the Howard County Consumer Protection Act division, or the CPA division over there, all under the umbrella of it being a one-year statute of limitations. And finally, I would just note, I know we have an abbreviated hearing today. I do know the Howard County Chamber of Commerce, the Maryland Bankers Association, Maryland NFIB, the Maryland Retailers, the Maryland Realtors, and I know Kathy Howard from Maryland Multi-Housing Association also signed up in opposition to this bill. Thank you, Mr. Chair.
Good afternoon, Chair, Vice Chair, members of the committee. My name is Hugo Cantu, representing the Apartment and Office Building Association. We represent 167,000 apartment units between Montgomery and Prince George's County, and I'll keep it short, but I think the main point is we didn't even submit anything official in the House until the proponents came in and said, you know, is heavily focused on housing providers and landlords. And so now we're here with you all and with the chamber, and we agree with everything that the chamber has said. And again, I want to reiterate, I think Baltimore City has been brought up a lot, but this is going to affect Montgomery and Prince George's County. Montgomery County had I think it's Bill 625. That's the one that added landlords. Prince George's County did something similar last year, CB 48. So, and both of those languages are different from each other. So not only are they, if they are identical to the state, which again, I'm not entirely sure, they're then different from the state and now different from each other, and they're right next to each other. So we're asking for an unfavorable report on House Bill 1105. Thank you.
Excellent. Thank you all very much. Questions from the committee? Oh, sure. Senator James.
I just need a refresher because I know we had heartburn when we were debating giving the Attorney General this Consumer Protection Authority. And I do remember our debating, maybe I voted against giving him sort of unlimited on the statute of limitations. I remember this debate. I remember we came in and we were showing him there were only two, you mentioned, I think there are two places in Maryland statute where we're beyond the 1 year, and I don't remember the policy reason for that. My thought is that it might be because this is empowering government, not a citizen. And you might look at a citizen differently and say they may get that 3 years because just their disparate knowledge or lack of knowledge. But when you're dealing with a governmental agency, and I understand they may be bringing it on behalf of people, but they have a more sophisticated situation. They have a shop. Can you speak to that? Because I think that's why we even have a 1 year often on government enforced consumer protection as opposed to an individual, unsophisticated individual who might then discover something and then possibly bring it, not under, let's say, Consumer Protection Act per se, but bring a claim for some kind of harm done by something they have bought. But maybe with the government enforcement, we've been a little stricter because of the heightened place they are, the powers that they have to go after private entities. Can either or both of you speak to that?
I think so. To your point, and the proponents referenced this, a claimant under the CPA has the 3 years after they knew or reasonably should have known. And so what they're trying to do now is extend that an additional step to when the local authorities knew. So a claimant could know for 7, 8 years, sit on it, and then not even alert the authorities, and the statute under their bill wouldn't begin tolling until they've told the authorities.
Right.
And I think to your point, you need to look through the Courts and Judicial Proceedings article. What you see is a lot of references to from the date the offense was committed, and that's actually how this bill was introduced in 2024 before they tried to amend it.
Yes, and I don't know if there was any evidence in the House about all kinds of claims going unenforced. They were unable to, but unless I see a giant number of those, if it ain't broke, don't fix it. If I don't see a lot of cases in which, darn it, they weren't able to, operate as they wanted to. And I'm sure there are anecdotal stories, but I'm saying en masse. And I don't know if you all are familiar with that being lodged as a reason to extend this.
No, Senator James, I appreciate that, and our sentiment is right along with yours, and especially with the understanding that anything could be referred to the Attorney General's office.
Right, that's true too.
One, and then two, with the fact that I believe the city just set up their Consumer Protection Act statute around 3 or 4 years ago.
Right, and then I just take you just to confirm, you all just said that we already know that, well, Baltimore City, and I appreciate the delegate telling us that Baltimore City's code is identical or nearly identical, which that's not mandated. So that's a problem. But you're telling me, guess what? There are 2 other jurisdictions, or at least one, that does have another code. It's not identical at all, and it's expanding in nature, and now it's expanding in the amount of fees and fines. So we already have a problem in that we're going to already have at least 2 of the biggest jurisdictions with different codes for businesses to try to manage even when they are trying. Is that correct?
Yeah, us too.
All right, very good. Thank you, Mr. Chairman.
Mr. Chair, Mr. Wiggins, I think in your testimony you mentioned Senate Bill, I wrote it down as 209 as removing any cap on damages.
I believe it's 209. I'll get you the copy of the bill. I believe it is 209.
I tried to find Senate Bill 209. It doesn't. That's not it.
It may be 290. But we're so late in session, my numbers get a little mixed up sometimes. But I'll get you the copy of the bill.
Yeah. Could you get me that? I'd like to take a look at that particular bill.
Yes, sir. I will get that to you.
Thank you.
This is a data call for maybe Delegate Embry, but the case about the statute of limitations or that there are no statute of limitations, do you know what the citation is, or could you help us find that case?
For the Attorney General's office?
Yeah.
So it's their argument because it's the law, I think, is silent. So
Okay,
I can send
yeah.
you, I'm forgetting his name, but one of the Attorney General's office lawyers prepared a memo in connection with that.
Got it. So has it been litigated, or is
It
it?
has multiple times. Oh, I'm sorry. Oh, excuse me. In the matter of addition of Cricket Wireless and AT&T. I'm sorry. Yes, there have been more than one.
Got it.
And
But-
and I kind of give.
Yeah.
May.
We'll just, you can leave it. We'll come get it. But that's the most recent one?
But
Okay.
there have been more than
Okay.
one I'm aware of.
All right. Thank you very much.
Thank you.
Thanks.
All right.
Okay. Seeing no further questions. Oh,
It's 290. It's
290.
290.
Okay. Seeing no further questions, thank you all very much. Thank you. All right, with that, thank you, Delegate Embry. That'll conclude the hearing for House Bill 1105. I see Delegate Riley's here. She was next in line. So House Bill 1439.
Good afternoon, Chair Smith and esteemed members of Judiciary Proceedings Committee. For the record, I am Delegate Teresa Riley, here from District 35A to introduce House Bill 1439, Real Property, Partition of Property, Liens, and Purchase Price Adjustments. This bill makes a few changes regarding the petition process. a legal process where the court divides real property among multiple people. What the bill does, very simple. If the plaintiff fails to produce a title report, this bill requires each party in a timely notification to the court the outstanding liens and the income from the property with supporting documentation, and alters the calculation of the purchase price for the co-tenant's interest by subtracting the total value of those outstanding liens and also taking in consideration the purchase price adjustments owed on the property from the value of the entire parcel. This bill had no opposition in the House. There were 2 friendly recommendation amendments from the Maryland Judiciary and also the Maryland State Bar Association, which I did take, and that is within the bill that you have in front of you. It did pass the House unanimously, 135-0, and I respectfully ask for a favorable report. And happy to take any questions.
I just want to say this is another delegate from Harford County, and I don't know if this is the first time you've been here, but
Yes, it is.
So it's so good. Welcome, and thank you for bringing this good bill.
Thank you.
And, Senator West and I often work on bills like this, too. They're not exciting, but I think they're so important, and they make people's lives better in some small way. So thank you so much for taking the lead.
It's a very fair bill.
Yes, there you go. Thank you.
Thank you so much. I appreciate it.
Excellent. Thank you very much, Delegate. And seeing no further questions, thank you.
Thank you.
Great. All right, that'll conclude the hearing for House Bill 1439. I see Delegate Ross is here. Let's come with Delegate Ross with House Bill 1506. Delegate Ruff, you're next, and then Delegate Guyton, and then Delegate Cardin and Ahrens. There you go.
Hi, Mr. Chair, Mr. Vice Chair, and distinguished members of the committee. It's very nice to be here. This is only my second time in this committee. So I am here, I'm Delegate Kim Ross for the record, and I'm requesting a favorable report for House Bill 1506. This bill, let me just tell you a fun fact. If you live in a homeowners association or a condo association in Maryland, you may be charged a new owner fee. It's also referred to as an initiation fee or a capital contribution fee. That fee has no cap, and it's set by the community. So it's paid at the closing table, and if you don't pay it, just like any of your other closing costs, then that can jeopardize your ability to make your home purchase. So this is truly a barrier to home ownership if you cannot pay it. So these fees are a part of your resale disclosure package, although currently it is not clearly defined in your resale package, and it's typically, the cost is typically 1 to 3 months worth of your assessment. So if your monthly assessment is $100, it typically would be $100 to $300. In many cases, it's much more than that. And again, there's no cap. The fee can go toward reserve funding. It could go toward your operations budget. So it has a place. But typically, these fees in a new development make sense because you're building your budget, you're trying to establish your starter money. And so this bill excludes new developments. This is for resales. And I do want to highlight this bill did pass unanimously out of the House. It passed unanimously out of the committee as well. And I was very happy to see the bipartisan support for the bill. But currently, these fees in a resale environment, it's a bit of a money grab. Okay, it's something that you can do, but without a cap, it can spiral way out of control and keep someone from buying their house. So I just want to clarify, because I don't know what you see there in your packet, and you may have this, that this is not, it's not a part of the typical funding stream for an HOA community. The monthly assessments serve that purpose. That is how an HOA or a condo association raises their money to do what they do. They do it by collecting those monthly assessments. This fee is something else that's charged up front to a homeowner who's not even moved into the community to benefit from those services as yet. So this bill would cap those new owner fees to no more than 3 times the monthly assessment that's charged to all the homeowners in that community. Originally, you may see this bill capped that fee to 1 month's worth of assessments. The goal was to make sure that a new homeowner would not pay a penny more than anybody else living in that community paying that month. That was the original bill. It was later amended to 3 months' worth of assessments. Excuse me. The bill would also exclude master plan communities. That was an amendment that came along later. And lastly, the bill requires a disclosure statement of the fees, and it specifies how that disclosure needs to be written so it's crystal clear to the new homeowner what they're being charged and why they're being charged that fee, or at least what that fee is. So this bill would avoid any excessive surprise fee at closing. It would prevent a community from using this fee as a discriminatory tool to say, let's exclude all of the low-income people from moving to our community. They can do that now. You can say, let's set this fee at $10,000, and let's keep some of the XYZ, whomever you're trying to exclude individuals out of your community. So this bill is about affordability. It's about access. It's about transparency, and it promotes home ownership. We need this bill. And we need it right now. People are struggling to afford life in Maryland. We all know this. We hear it every day in our offices. Anything we can do to help people afford life here, we should do. And home ownership is key to that. It's the biggest line item on anybody's budget. Buying a home is one of the biggest purchases anyone will ever make. And so we want to remove any unnecessary barriers to people being able to do that. Now more than ever, common ownership communities are being faced with a new legislative hurdle that some of us here know, requiring them to fund their reserves to a specified level. And this has resulted already in thousands and millions of dollars being assessed to homeowners. This fee could be used on top of those expenses by an HOA or condo association to meet the gap on the back of a new homeowner who wasn't there and had no role in whatever those expenses may be. We want to discourage that. I ask you, would you like to be charged, say, an extra $10,000 at the closing table because that community is trying to meet, bless you, Mr. Chair, is trying to meet a financial gap, whether it's due to reserve or whether it's due to some other more nefarious reason? Maybe they've mismanaged the money and they have this financial gap. I don't think you'd like to have that gap met on the back or at the expense of you as a new homeowner moving into that community. So this bill addresses yet another barrier to homeownership, just promotes responsible, ethical, and equitable fees in our common ownership communities. And lastly, I want to point out, I'm sure you may have in front of you a letter that we did get just a couple days ago from the Office of Consumer Division within the AG's office, and they did say, and I spoke with them just as recently again as yesterday, and they noted in the letter that they had concerns about the amendment that capped this fee, moved this cap from 1 month's worth of assessments to 3 months. They like the bill. They're very clear about that in the letter. They were clear about that in their conversation with me. Their concern is that they liked and preferred the more strict enforcement of this, which keeps it at 1 month. I don't disagree. That's where this bill started. We got to the 3 months in a compromise arrangement because there was a key stakeholder who wanted to see us give a little bit more on that. And so we raised it to 3 months. There was some data that supported it on average. Like I said, I believe at the beginning of this testimony, the fee is usually 1 to 3 times the monthly assessment for people who are doing this the right way and are not using it as a money grab. The Community of Association Institute, they did say a lot of their members, that's kind of where they hover when they're doing it right. And so for that reason, I felt 1 to 3 months is reasonable. We came to that. We moved to the higher end of that. If you decide that, given the input here from the division, if you decide to take that back down to 1 month, I would be amenable to that, absolutely. With that, though, they do support the bill. They came in with some even stronger language than what I'm saying to you now regarding how important it is for us to rein this in and cap this fee. and promote homeownership here. I respectfully ask for your support. Join me, join the House in supporting House Bill 1506, and I thank you for your time.
Oh, thank you, Delegate, and thank you for such a clear presentation. I'm not as familiar with this particular issue. I have represented a lot of homeowners associations in litigation. So do you happen to know the history of this kind of capital contribution initially? And it was obviously never capped until you're bringing it up. So just when we first started doing these common interest communities, what was the original understanding of that area of charge that would usually be assessed on the new homeowner?
Thank you very much, Senator.
Condominium owners.
Sure, thank you, Senator. That is a good question. So originally, these fees were for primarily your new developments. So it was a way when the homeowners association was under the development board, which has the ownership before, right, and then they turn it over to the resident board. It was a way for them to build a starter fund. So it makes sense in that lane, and that's why this bill rightfully excludes, the new bills from collecting that fee.
So you made sure that does.
Yes.
Okay, and then I just want to make sure, because of the whether we like it or not, what happened in Florida, then emanated across the country, and now we have more reserves. This in no way would limits these various associations when they need to replenish or increase their reserve funds. Is that correct?
That is correct. So with this, in fact, what it does, it encourages communities to do that the right way, which is through monthly assessments, special assessments, which you sound very familiar with, is really the fund. That's the revenue source, and that's the way they should be raising the money to address repairs, maintenance, et cetera, and discourages them from pushing that to a new homeowner.
Are you aware, because I don't know, so I just want to make sure we're not tripping over ourselves. Are you aware of, it totally makes sense to me to do a capital contribution for a new owner to build up your reserves, right? Because you can't wait 4 or 5 years, right? So unfortunately, those new people are gonna, but I just want to make sure, I've not heard of a case where later in the ownerships, the property's ownership, we're now on a third or fourth owner, for some reason, whether or not there have been instances where a capital contribution might be needed and might, for some reason, be needed more than what you're capping it at. I haven't heard anything. Have you heard of any cases like that? And then I have one last follow-up question.
No, and I'm so glad you said that.
Yeah.
No, not needed, no.
Not needed.
Yeah.
And so then I guess sort of the only thing is, I also haven't heard about a lot of this being a problem. Now, you seem to be indicating it could be, but did this come to you because you were hearing about capital contribution fees? You're not just worried about transparency, because we could make this just, hey, make it more transparent. You also want to cap it. Were you hearing about this in various communities where this was being used to either keep people out, or you just thought that it was a surprise kind of thing, that transparency wasn't as good as it should have been?
No, and thank you, Senator, for that question. And I want to couple the two, the last question and this one together, because when I say no, not heard of an instance where it was needed, that is subjective to me. It did not appear to be needed. Yeah, but
whatever prompted.
Sure, yeah, but absolutely know of cases where this fee is being charged on established communities, even much older than 3 years. We knew of a community over 20 years old that was doing this, and so I wanted to clarify that. And yes, we did hear from communities that are doing this. Even in testimony, when we had this over in ECM, there was the CAI, I'm sure you're familiar with, who were there, and they talked about familiarity with this, and they too had some struggles with having this fee and needing to take a look at it. They totally agreed in that testimony that yes, we should be looking at how much we allow this fee to go up, and so it came from an actual issue of having this fee.
So I guess what I would say is that if for any reason we missed something here, we could come back. If somebody came back and said, look, here's where we need it and why we need it, you could say, all right, then we can make an exception. We'll be very deliberate in how we would allow for some exception, some extraordinary circumstances. But I think, the way you've worked it out and tried to work with everybody, it looks like you did a good job.
Thank you.
All right, thank you.
Senator.
Thank you very much, Senator. Further questions for the delegate? All right, Delegate Ross, thank you very much.
Thank you, Mr.
Good to
Chair.
see you. Thank you. All right, we'll now hear from Delegate Ruff with House Bill 130.
Hang here for a second. Good afternoon, Mr. Chair, to the Vice Chair, and to the whole committee. Based on the fact that we were on the floor earlier, I had arranged for my Chief of Staff to present this bill, and her name is Shivani Sid, and I was wondering if the committee would be willing to hear from her since we had prepared that, and would love for her to get the opportunity to testify. Thank you, Mr. Chair.
Thank you so much. Can you all hear me all right? All right, perfect. Thank you so much. Mr. Chair, Mr. Vice Chair, and members of the committee, thank you for the opportunity to present House Bill 130 with Delegate Ruff. At its core, this bill is about equipping our state with the tools that will protect generational wealth, shield vulnerable older adults, and stop bad actors who are exploiting gaps within our law to steal homes, land, and livelihoods. For many Maryland families, particularly Black, brown, rural, and working class families, real property is the single greatest asset that they will ever own. It's the anchor of generational wealth. When deed fraud occurs, it doesn't just take property. It wipes out decades of sacrifice. It destabilizes families. And it often leaves people displaced with no clear legal remedy. HB 130 is an attempt to close those gaps. Last year, over 11,000 U.S. property owners lost a staggering amount of $350 million to real estate fraud. Unfortunately, this crime is also on the rise. Home title theft and deed fraud are becoming alarmingly common. Criminals have been exploiting gaps in the legal system and increased access to public records. Many victims don't even discover the theft until it's too late. This leaves them with a complex legal and financial mess. As amended by the House Judiciary Committee, House Bill 130 establishes a deed fraud task force. This piece of legislation elevates the fact that we need data, coordination, best practices, and prevention tools, especially for seniors and heirs who are disproportionately targeted by deed fraudsters. There's one proposed sponsor amendment that Delegate Ruff will be offering to the committee for adoption. The amendment would remove the Office of the Attorney General as the staffing agency for the task force and instead replace them with the Department of Legislative Services. To illustrate this dire need for the initial step in combating deed fraud within our state, I want to share the story of Robert Harris. He was a farmer from Kent County who unfortunately cannot be here today, but his experience underscores why this bill is definitely urgent. Mr. Harris received a call from a neighbor one day inquiring why his family had never told them they were moving. Confused, Mr. Harris searched online, and then he discovered his family's farm from multiple generations had been listed for sale on multiple real estate websites. After investigation, it was learned that someone had created fake passports and then used them to pass by the online identity verification platforms, therefore fraudulently transferring ownership of his land. The IP address had been bounced between different nations and different states, appearing finally in Delaware, but unfortunately, law enforcement told him that the case was essentially impossible to solve. Imagine discovering that your family's land, your livelihood, was stolen within a few clicks. The law, unfortunately, offers no real path to justice. My apologies. Members of the committee, HB 130 gives Maryland the tools to learn how we best can prevent that outcome here. I respectfully ask for a favorable report, and pass the mic to Delegate Ruff for further questioning.
Excellent. Very good testimony, very thorough, and composure. They're all 10 out of 10 on that one.
I agree, Mr. Chair. Thank you.
Questions from the committee? We have a question from Senator James.
Thank you very much. I don't know if you want your staff to answer the question. I think it's an easy question. Your voice trailed off, ma'am, and I just didn't hear the story. I was really listening to the farmer from Talbot County.
From Kent County.
Kent County. And his neighbors think he's moving and he wonders why. And he learns that people have done fraudulent documents in varying ways that enabled them to create a fake deed. But was that successful? It seems to me the farmer you know, basically go to court and say, or go somewhere and say, I don't think so. This is all fraud. I just want to know the conclusion, ma'am. I didn't hear the end of the story of the farmer.
I think he was ultimately able to retain his property.
Right.
But if it hadn't been caught in time, I think that that's the biggest issue. And that's the big reason why we need this task force, so that we have the data. Initially, this bill proposed much more sweeping changes to our laws to add this as a felony offense. Number one, that would have enhanced penalties, to also create a deed fund that would support victims of deed fraud like Mr. Harris. I think ultimately the committee on the House side determined that we need more data. We need to understand it better before we take the next steps.
I actually applaud you for that, because I know we are all tempted to want to write the bill. We think we've got the solution, but most of the time we've got some information, but we don't have the whole picture. So I think it's much smarter to come in and do that, because I'm concerned myself, but I'm not sure how successful these are. But even if they're not successful, they certainly are disruptive. And for somebody to have to go out and own the property, minds their own business, and suddenly finds they might be fending off claims that their property is no longer owned by them, is still something that they shouldn't have to endure. So I like the idea of the task force.
Thank you, Senator. And if I could just comment just briefly on following up.
Yeah.
There are so many stakeholders that have an interest in making sure that we study this and have a comprehensive plan for our citizens to protect them from this rising scourge. So from bankers to realtors to even the public defender's office, even though they did not want us to make this a felony crime, they still are interested in participating. And so I would love for the committee to do its work and to find a way for us to establish this task force.
Well, we've got a concomitant problem with people now squatting and going in and sort of claiming they own a property when you're away. So this is kind of a contagion that we have in our state and across the country. I appreciate you taking this on.
Thank you, Senator.
Thank you.
Thank you, Mr. Delegate, for bringing the bill. Do appreciate it. So in the sugar boots, I'm sorry. In this task force, I assume we are going to include the local government and the burden, because there's over 100 statewide local enforcement agencies, and if they have to reprogram their reporting systems to meet the bill's requirement, there's going to be a tremendous amount of local cost to IT and cost burden. So hopefully this task force will address possibly the state helping out local governments facing a possible fiscal 2027 expense.
Understood. I think that that's something that can be amended into the bill, or at least considered as far as tasking the task force with thinking about that.
I think it's the people that you put on. I just want to make sure that ends up getting answered. So
understood.
Putting it on the record.
Thank you.
Takes care of that. So thank you, Delegate.
So the amendment is simple enough, we can do it in line, but do you have the amendment just swapping out the OAG for DLS, or?
I believe it's been filed with the amendment office, but I don't think we've gotten it back yet. We just put it in today.
God bless. Every time I try to make DLS staff something and I put in the amendment, it just gets lost. I don't know what happened. It's like, yeah, I'm kidding. All right. With that, seeing no further questions, thank you all very much. Thank you.
Thank you, Mr. Chair.
Thank you.
And great job, Ms. Sid.
There you go, yes. All right, with that, that'll conclude the hearing for House Bill 130. We'll now go on to Delegate Guyton with House Bill 1381, and then we'll go to Delegate Hardin.
Thank you so much, Mr. Chair, members of JPR. I want to first thank you for your patience and your kindness yesterday, particularly Senator McCray, who came and actually gave me water. Didn't solve the problem, which was an exacerbated asthma attack, but I'm prepared for you today. Here's my inhaler, just in case anything happens. We're all good to go. And if you do have any questions, yesterday's bill was great, even though I had a hard time getting through the hearing. But today, Senator West stepped out, but for his benefit, I was going to say I'm here to present to you respectfully House Bill 1381. It is short, it is easy to read, and it is really, really easy to comprehend. So when he does come back in, you can point out those three things to him. It simply prohibits drivers of vehicles from stopping, standing, or parking in a bike lane or bike path. The legislation supports Maryland's Vision Zero Complete Streets goals by changing drivers' behaviors, but it's not only offering a safer environment for cyclists, it's also offering a much safer environment for people driving cars so that cars don't swerve out around cyclists and have other cars hit them, and for pedestrians on the road. This bill authorizes, this is the important part for this very judicial committee, this bill authorizes local control over a lot of timelines here. They have timelines for delivery vehicles in the bike lanes. It requires exceptions for inoperable vehicles, transit vehicles, and vehicles picking up or dropping off people with disabilities, something near and dear to my heart. The vehicles also must not stop in the bike lane, even under these conditions, if there is another spot nearby on that block. So we all have seen delivery vehicles, et cetera, double parked, where there might be a spot right next to them. They need to take that spot, or they might be ticketed in this case. So there are already provisions in Maryland that do exempt emergency vehicles, first responders, and transit vehicles, so they're all good as well. This legislation puts the state of Maryland in line with Baltimore City, Washington, D.C., and with Virginia. So I am here to ask for a favorable report on House Bill 1381. It passed bipartisanly on the House floor, and there is one amendment that is being presented to you with a favorable amendment, I believe, today in your packet, and that just clarifies some language saying that local control can also be authorized in cases where there is construction going on in the block or on the block. If you decide to take that amendment, it is not on our bill. If you decide to take that amendment, we will conform to it in my committee. So thank you so much, and I'm happy to answer any questions. And I'm still breathing, that's good. Success.
Yes. And good afternoon. Just to be clear, so I'm understanding, what is a vehicle under this law?
A vehicle is an auto vehicle, and this falls under motor vehicle
Just talking about cars?
Yes, sir.
Thank you.
Not a bicycle or a unicycle. We do try to cover unicycles in our committee often.
All right, seeing no further questions, thank
All
you
right,
very much.
thank you so much for your time.
Thank you. All right, well, that'll conclude the hearing for House Bill 1381. We'll now move on to Delegate Cardin with House Bill 638.
Thank you, Mr. Chairman. I have my witness here as well, who'll be standing here, be able to testify after. Thank you, Mr. Chairman, members of the committee. John Cardin on behalf of House Bill 638, asking for your favorable review. This is, I believe, a very important piece of legislation, and I thank you for your indulgence in letting me testify. This will increase the mandatory retirement age for judges from 70 to 73, just 3 years. What the bill does, and let me just highlight this in the beginning, is it saves the Maryland taxpayers upwards of $21 million, according to the fiscal note, and perhaps significantly more depending on the actuarial report done by Department of Legislative Services. 638 is something that that many states in the country have been reviewing, and most have pushed those who have retirement ages have pushed retirement ages up for various and sundry reasons, not the least of which is that this was originally passed in 1851, as you will learn from Mr. Santini, who knows the entire history, not that he was here in 1851, but, the median age at the time, I think you mentioned, was 55. At the time, it was the time that often people died. So 70 was considered very, very old. Nowadays, the median age is upwards of 80 years old for in somewhere in that range, 78, 79. So 73 is much more appropriate. The other, and I'll let Mr. Santini talk more. He's really the expert on all of this. We did have this was bipartisan. This is simple. We had an amendment from the minority party, which was accepted on the floor, which made sure this was only prospective. So we are not going to be dealing with present judges, and that was an issue that was related to the fact that you bargain you get what you bargained for, and present judges bargained for a 70, so they shouldn't necessarily benefit from this. The other addition to this legislation, which came welcomed by the Orphans Court, is to include the Orphans Court judges in this legislation. We had 3 Orphans Court judges die in the span of 1 month in the late 90s. They were in their late 90s. That didn't happen in the late 90s. They were in their late 90s. 3 of them died. 2 were in the same jurisdiction. They didn't have an Orphans Court judge there. They had to wait. They had to have a visiting judge come in for about 45 days while the appointment process was happening. So this is something that's welcome. Just we wanted to make sure that there wasn't a conflict in that, and we got an opinion from the Attorney General saying that there were no problems with either of those amendments. I can continue to talk about why this is really important, but I will say that our committees, the Judiciary and the JPR, don't often get a chance to give the state some money back, and this is a great opportunity for us to do it in a way that is certainly, there's really, for all intents and purposes, no opposition except for inertia. Why are we changing it? It's the appropriate thing to do. Why are judges the only ones who can't continue to work while they're still able to? The final thing, if you're wondering why it saves money, obviously actuarially, there's the morbid issue of people will be working longer, so therefore they will be receiving pensions for less time, and that's the major reason why. And then the minor reason why is because presumably, at least according to the fiscal note, whether that's true or not, we'll have to wait and see, is that there will be less need for senior judges. So for those reasons, I ask you for a favorable report. Mr. Santini is the expert, but I'm happy to answer any questions after he testifies.
Good afternoon, Chairman Smith, Vice Chair Wallstreicher, and members of the Judicial Proceedings Committee. My name is Raphael J. Santini, and I am a proud practicing attorney. I've been involved with the Maryland court system since 1979. That's over 46 years. I am here today to support HB 638. Life expectancy and workforce longevity has increased since the enactment of Article 4, Section 4 of the Maryland Constitution in 1851. Life expectancy in 1851 was around 40 years of age. Life expectancy today is around 80 years of age. Maryland is surrounded by jurisdictions that have a higher retirement age than Maryland. The judicial retirement age in Pennsylvania is 75. The judicial retirement age in the District of Columbia is 74. The judicial retirement age in Virginia is 73. At one time, it was 70, and the voters decided it should be 73, which we are seeking. The judiciary does not resemble the Maryland State Bar Association. The Maryland State Bar Association consists of 64% private practitioners and 25% public practitioners. The current judiciary is made up of more than 25% public practitioners in their respective jurisdiction. Let me be clear. I am totally respectful of the public servants and their commitment. However, the current judiciary does not represent the Maryland Bar Association. A review of the judicial vacancy and candidacy and judicial appointment statistics from 2022 to 2025 shows 70% of the appointed judges were from public service as opposed to 24% from public service. Supporting HB 638 will create a more representative judiciary by allowing private practitioners accessibility to these positions. Accessibility of judicial positions for seniors attorney. Most younger attorneys cannot afford to apply for judicial positions because of economic and family and lifestyle demands in their 30s, 40s, and 50s. In their later 50s, their economic demands are less, which allows senior attorneys with a wealth of subject matter knowledge and experience the opportunity to join the judiciary.
All right.
Okay.
Excellent. Thank you very much. Senator Muse has a question, please.
Thank you.
Happy to.
And thank you for bringing the bill. What made you settle for 72 and not,
What made me settle for 73 instead of 72 or 74?
I'm sorry, yes, say it again.
Okay. So we looked at what was going on around the country, and most states, and particularly in our region, are somewhere between 73 and 75. The Orphans Court is at, they're unlimited, so we didn't want them to necessarily go down to 70. So we thought that 73 actuarially makes sense. It saves us significant money, but it doesn't move us to a place where we may be getting, where there are issues with older judges, right? So, and their ability to be able to manage, although I'm in front of many senior judges who are more expeditious and more knowledgeable than some of the younger judges. So, but we just believe that 73 probably is something that, number one, the voters would be willing to accept, and number two, would be commensurate with what's happening around the region.
Okay, thank you. I asked that question because I'm 68. Well, in 2 weeks, I'll be 68. And I feel good. I can think well. Okay, he's got to go.
If you think that it should be older than that, and although I will tell you that getting it back to the House after our debates,
okay, I will do that.
And starting again, but that being said.
I do think so, because Supreme Court judges, they are there for life.
Federal judges are there for life.
They're there for life. So I don't even know why we have this age limit to judges who have a wealth of knowledge. They are healthy. They think right and think great, and they have, that experience. And so I don't want to send it back to your committee with 75 because I don't want it to die. But
fair enough.
Just something for next year that we may want to look at. And I know, in my opinion, it's kind of close to age discrimination, right? Kind of close to age discrimination. And so my uncle was a judge down here, right, right across the street, Judge Clayton Green.
Oh, yeah.
And he thinks really, he's, retired, but he thinks extremely well and does extremely, well. So, I'm going to retire probably when I'm 74 so that I can island hop and island hop. Right? But, yeah, maybe we can revisit this next year.
Well, first of all, my regards to your uncle. Please say hello. I've been in front of him a number of times, and I know that Mr. Santini has as well. And I resemble those remarks and agree with you, and couldn't have said it better myself.
Thank you, and thank you, sir, for coming and doing that. Thank you, Mr. Chair.
Thank you, Delegate Cardin. Somebody had to bring this bill. I'm glad you did. I did just want to clarify one thing. Your testimony was that the age 70, mainly my question is for you, but for you, was 70 actually put into the law, I guess, in 1851? Is that what you were saying? Yeah, geez, that's like saying 100.
People were
like 100 today. Right. But I wanted to just echo a couple of things. One, my dear friend Kerry Dealey became a federal judge right close to 70.
Right.
And he did it for exactly why you said. For private practice lawyers, it's a step down, money-wise. Not for young government lawyers, it's a step up. So that's why we've got the wrong mix, or at least I'd say not the right balance. And my uncle, brilliant man, spent most of his legal career, Judge Higginbotham, as a retired judge. Harford County, and he was an appellate. They put him on the appellate bench. So it was a little weird because, he got there later in life too, because of private practice. but he was so damn good that they kept bringing him back to the appellate level. But it was odd because he's like, I'm pretty vibrant and young, so I just think you're so spot on about that. But I do just have to say something. Federal judges, because I work for them, they get into emeritus status. So that's the Supreme Court is for a lifetime. When you get to a certain age at the federal court, they do watch you and put you in a different category. So I think you've struck the right balance of picking an age that's moving us in the right direction. I'm not sure I'd be ready for no age limit because the judiciary can bring you back. But I like your age increase because the judiciary can disqualify a judge, God forbid, for, just have a judge nudged out when age really is an issue.
One of the things that was at the end of Mr. Santini's testimony that he wasn't able to say is that if there is a problem with a judge who, because of age, an age issue, there's always the judicial disabilities, which is active, and believe me, while it's not frequent that judges are removed or censured or other, it will happen if they're incompetent, and that is there, and it has happened.
They don't like that.
And Judge Deely, you mentioned, who I love to death, promised me lunch like 4 years ago, and we still haven't gone to lunch. So I'll remind him of that. Thank you for reminding me about Judge Deely.
All right, you're a friend of mine. I love him. Okay, thank you.
Thank you. I may come at this from a different angle from my colleagues. And I wonder at what age people just want to retire instead of trying to make people work until they're dead. I mean, this is no judgment, right? This is no judgment on their senility or anything like that, but you have a long line of attorneys that want to be judges. And I remember we've had this discussion years ago and many times fought it off because of that. Whether it was diversity arguments with more men and women getting on the courts today versus in the past or whatever. So I guess I'm wondering again, the point in trying to raise it from 70 to 73. I mean, what's wrong with 70?
That's right. So first of all, I'll bring back the argument that Mr. Santini mentioned that it is harder for you, especially in today's age where there's a tremendous amount of debt that you may be facing and young families to have to deal with. It is harder to seek from the private sector. It's harder to seek a judgeship based on your family needs. So so if you can do it a little bit later in life, and this allows you to do it a little bit later, you can. That's number one. Number two, I'll give you 3 reasons, and then I'm sure that you've got a response to me. The diversity issue, which has been brought up many times in the past, and as a supporter of ridding us of judicial elections, it's a whole other argument, which we didn't tackle this year. I think that the message has gotten loud and clear over the last 3 administrations, and I think that the bench has demonstrated, and Baltimore County is a perfect example of how it is moving into a very diverse group, and that is not something that's going to be changed simply by judges being able to stay a little bit longer. And the third reason, piece of information is that while judges would like to fully vest and qualify for any kind of retirement benefits that they may get, they're not required to. They can retire at any time they want. So if a judge chooses to retire early, they can. It generally takes, I believe, somebody also correct me, it takes 16 years to fully vest. If you're appointed at 40, you could retire at 56. Vesting, now you may not be able to get your retirement benefits until you turn 66 or whatever the state law is, but you will fully vest in whatever that amount is, regardless of whether you're 73 or not. So for all those reasons, I don't think that extending the age is going to inhibit everybody's ability, but we can continue to have that discussion. I mean, but for those 3 reasons, I would say that this is not going to harm young people's ability to apply for and become a judge.
Is this a creeping towards a lifetime appointment?
Well, I would be adamantly opposed. In fact,
but every few years, I mean, as age extends, so we'll move it up a little bit longer. I mean, is that where we're going?
I mean, We're the legislature. We get to decide what these are. And
That's true.
I don't believe this is a slippery slope. I mean, I've seen lots of slippery slope bills this year. This is not one. This is a constitutional amendment. It requires a tremendous amount of support from not only us as a constitutional amendment, but also from the voters. This is not something that happens willy-nilly.
Thank you.
Yep, thank you.
Thank you, Mr. Chair. And thank you, Delegate Cardin, for bringing this bill. I think it's a great bill. We've needed it for a long time. I think it's totally appropriate that we increase the retirement age to 73. I would not want to go to 76 or 80 because that would require, I guess, the chief judge to have difficult conversations with judges who are beginning, really palpably beginning to show that they're now no longer able to handle it. Difficult, unpleasant, embarrassing conversations, or referral to the Judicial Disabilities Commission, which nobody wants to do. So I think 73 is an appropriate age to use. I just want to ask about the other issue that always has come up when I've discussed this with people, and that is the governors like to make judicial appointments. So if we increase the age to 73, there are going to be a lot of, many of the judicial appointments occur not because judges voluntarily retire, but because they reach the mandatory age of senility, and the governor therefore gets to make new judicial appointments. So have you had any conversations or any reason to believe that the members of the governor's staff or the governor himself would have a concern about extending the tenure of existing judges an extra 3 years, thereby depriving him of the opportunity to make appointments?
So you came in late.
I did.
But thank you very much for the question. It gives me an opportunity to talk even more. So number one, we had an amendment, a friendly amendment from the Republican caucus to make this only prospective.
Fine.
So this administration will not be impacted at all. In terms of future administrations.
Would prospective mean as of next January 1st when maybe the same governor is reelected, or would it be 5 years from now?
Once in theory, this would go into effect 30 days after the certification of the constitutional amendment. Okay, it would go into effect.
Yes.
So from that point on, any judges appointed, not judges who are, any judges appointed would be able to serve until they're 73.
Oh, I see.
It wouldn't apply to any of the judges who are presently on the bench up until that 30 days. So all the judges that we know right now that are there, they're going to be required to retire at 70.
I'm not sure I like that amendment.
Okay, I understand. It's your party. What can I tell you?
Why can't instead we have it take effect on January 1st, 2031, just before the next amendment? Well, the constitutional amendment won't take effect until after this.
I'll grab your ear before you draft that amendment.
We'll talk about this.
But let me also say that according to the experts here, appointed judges are being appointed older. So therefore, it will not reduce the ability for judicial appointments, because if instead of them being appointed at 40, now they're being appointed at 50, or if instead of being appointed at 44, they're being appointed at 48, whatever it is, that the change in the demographics allows for more judicial appointments, because they're going to be retiring just as soon. They're just being appointed as a little bit older judges, which is just happening holistically. It's not because governors are choosing older people. It's because older people are applying or will be able to apply. My problem is there are a lot of
great judges in their 50s and 60s who, if this Republican amendment is adopted, will have to retire or have to become constitutionally senior, and they can be called back, but they will no longer be.
They will be able to be senior judges
sitting at the time that they turn 70.
Right. What I said in the beginning is you get what you bargained for. When they were appointed, they knew that this was the rationale. They knew that that their retirement was 70. So
Kerry Dealey's a case in point.
They're going to get. He knew that he wasn't even going to qualify for the pension because he was only in for 4 years and 11 months, and we wound up being able to work that out through HR, and that was a couple years ago. But
Great. Well, thank you for bringing the bill. It's a great bill. I'm not sure I like the amendment, but it's a great bill. Thank you.
We have one more.
One more. One, we have had and we have now legislators who are 75, 78. They do their legislation and they do it well. I think I heard you say that, well, let me put it this way. If a judge happens to be, senility sets in when you can set in when you're 50 or 60, so I don't think that's a good reason. But if you had a judge who was 75 and began to show signs of senility or health reasons he or she could not come, don't you all have a process? That's what I thought you said. Don't you have a process?
So, and Mr. Santini, by the way, the former chair of the president of the Maryland State Bar Association, so he knows this stuff backwards and forwards.
Yes, we do have a process. It's called Judicial Disabilities.
Okay.
And I'm going to tell you, they're very active. And in my paperwork that I sent you a complete history. So there is a solution to that problem.
Okay. Okay. Yeah.
We just confirmed
I think they should be able to serve. I think they should be able to
commissioners
serve. I'm sorry. I think they ought to be able to serve until deemed that way by the board. But that's me.
Maybe we can set up a legislative disability committee as well.
It's called elections.
Now, I may not be here if you do that. Thank you.
But to your point, though, we just confirmed, Eric Barron was probably the last appointee we confirmed through the Judicial Nominations Committee, through the Executive Nominations Committee, rather. Eric Barron was for the Judicial Disabilities Commission, so just 3 weeks ago. All right. With that, that'll conclude the hearing for House Bill 638. We'll now move on to Delegate Arentz with House Bill 1614.
Thank you, Mr. Chair. Good afternoon, members of the committee and Vice Chair Wallstreicher. For the record, Delegate Steve Arentz, I'm here to present House Bill 1614 as amended, a bill established for the purpose of using lane direction control monitoring systems on highways under the Maryland Transportation Authority as amended. In an area where reversible traffic patterns and constantly changing road structure due to the use of gates, the enforcement of traffic laws is essential to safe travel leading up and entering the Bay Bridge area. As you know, I live and represent Queen Anne's County and on the other side, and the Bay Bridge has always been a traffic issue for us. The county has probably issued hundreds of thousands, or not hundreds of thousands, thousands of citations on this, but they're unable to keep up with the issues over there as people are traveling on that road. One of the big things, the bill did come in as my bill, and then I actually got bipartisan through amendments, which I thought was a big plus for me over in E&T. If you ever traveled this road, you could see that the state highway police, you could drive down it, and it's a real issue because it's about 1.5 miles up from where the gates are. And the biggest purpose of these things were the gate to protect it. And they pushed it up about 1 mile. And what happens is they have red lights going down, approaching the bridge on both sides. And what happens is everybody drives down, and they want to get all the way up to the front of the line. And you'll see a little bit of road rage there, and it's kind of comical sometimes. You'll be stuck in that lane, and with my delegate plates, I don't particularly want to be in that red lighted lane. But somebody will pull up beside you, and there's just no way the state police can really stop them and say, hey, don't do this, don't do this. This isn't a speed camera so much as it's a little bit of road rage goes on. You can see people getting next to each other, almost touching cars, and a lot of bad words, a lot of hand gestures that I don't appreciate because I'm not letting you in usually, so it's not like going over to Chick-fil-A. It's supported by State Highway. MDOT is a big proponent. I have my sheriff, my county, and MDOT in support of the bill. But I think it's a statewide bill now, so it's amended.
Thank you, Mr. Chair. Good afternoon, Delegate.
Good afternoon.
Thanks for bringing the bill. I'm a little confused. I thought from reading the fiscal note that it was for people who are driving the wrong way on the Bay Bridge, but you're talking about merging.
I'm talking about merging, where you come down, if you cross the Bay Bridge on a weekend when the lane's closed, you have two lanes, it's when there's contraflow.
Right.
Okay, contraflow state, that's coming over. That's one part of it, but when they do that, they actually close the far left lane on the eastbound side. And what happens on that far left lane, they have red light X's there with the two green.
Right.
People ignore the red light and just go all the way up to move to the front of the line.
Okay.
And again, you can argue either way on that because it's really just moving a problem.
So
And
it's
nobody obeys them. Not
Okay.
everybody. People do obey it because we do get traffic.
Okay, so it's not just on the bridge itself?
No.
Okay, I understand. Thank you.
Okay, thank you.
So, further questions from the committee? Senator James.
Actually, I just want to really thank you for this bill because I've seen this before and I wasn't sure how to address it, and I hope this is effective.
Well, it's a bill that's been around. We pushed this for a couple of years because and again, we have traffic problems over there where you can't get from the outlets up to the Kent Island. It takes you an hour and 45 minutes. So we're doing everything we can to expedite traffic, and this is one of the things that helps.
Excellent. Seeing no further questions from the committee, thank you very much, Delegate Aaron's.
Appreciate a favorable response. Thank you so
There you
much.
go.
Have a good day.
You too. So that'll conclude the hearing for House Bill 1614. We'll now move on to Delegate Naraki with House Bill 1508.
Thank you, Mr. Chair. Am I okay to start? Awesome. Thank you, Mr. Chair, Mr. Vice Chair, distinguished members. For the record, I am Delegate Ryan Naraki requesting a favorable report on HB 1508. This is a pretty simple bill. I know we hear that often, but this bill requires, upon submission of an application for a state highway access permit along any state highway for certain types of project, that notice is provided to each member of the General Assembly representing that legislative district in which the work is proposed. The notice would include some basic information about the project's type, the location, nature, the scope, those sorts of things. Just to give a little background about the legislation, I've had in my district, like probably many in this room, some big projects pop up recently that I had no idea they were occurring. This bill would not impact how those projects get approved. It wouldn't impact any of the timelines or any of those sorts of things. It just says that within 10 days of an application being submitted for an access permit, that the members that represent that district get notice about it so that we can engage with the community about the project. And frankly, I think the project that I'm referring to in my district, it would have had no impact in terms of how the project would have proceeded, but it would have, I think, impacted how the flow came in and out of this site. And I think it would have provided a benefit to the community in that way. I think it would allow the community to feel like they have more say in these kinds of projects. But it is not an attempt to any way stifle development or growth or anything like that. It's just to give some notice for us here, because ultimately we all know that we're the ones that have to go back and fight for those dollars to correct any issues that might exist along state roadways. And so with that, I will leave it there, Mr. Chair.
I think this is a great bill, but I got to ask you a question. Right now, I think I voted for this in my first term in the delegates in the 90s. But right now, I'm living in a traffic nightmare on 95 because I start my trip and almost the entirety of Harford County is under construction. Sometimes I don't know when. It's not always consistent, and all of a sudden it shuts down. It's inexplicable to me sometimes what they're doing. I know what they're doing. I know that we made a big commitment to improve 95 and widen it, especially north of Baltimore. So, but I'm not sure this bill would apply. I think this does not apply to the 95 and the bigger highways, or am I wrong about that? Does it apply to that? To the 95 construction as well?
Senator, it wouldn't apply to that. So
That's
what we're talking about, think very large either residential communities or very large commercial centers. Think your super Walmarts of the world
yeah,
along
I got Route
state
40,
roadways.
I've got lots of ingress
exactly,
and
like
egress.
Route 40, like Route 1,
Yes.
roads like that. It wouldn't apply to 95, 695. Those, it wouldn't be on those kinds of
Okay,
roadways.
so, and then is it that this is when the, let's say, because this happens all the time in my county, Walmart comes in, they hire one of my former law firms to work on their ingress and egress and all that kind of stuff. And then they're applying for some kind of permit to do that. Is that when this would be triggered so everybody in the community would know that the Walmart is going to want to having access to or is it that, yes, the project's been approved, but the permitting hasn't started yet, and this would let the surrounding people know, the legislators know, guess what, that Walmart project is going to start in 10 days. Is that what when does it kick in?
Great question, Senator. So how it would work is it doesn't impact any of the permits on the county side, for instance, that say your county and Hartford County might have to approve. It doesn't have any impact with that. When someone gets to a certain point in a development project, if it's along a state roadway, they have to file for the ability to access that state roadway.
That's what I'm talking about. What I just mentioned
Okay,
was
I'm
the state
sorry.
highway. That's okay.
So it would only apply to that part of the process, and it would be within 10 days of when that application is submitted for the state highway access permit. So that can occur at various points in the development process. Some projects are sooner, some are later. Senator, I also want to make clear that it's not for the individual that's trying to just put like a driveway to a home.
No.
We're talking big projects
I know what
here.
you're talking about, because I got a lot of issues in my county along the road, and these are hotly debated issues. Somehow everybody learns about them, but you're trying to at least get us to be in a better position, because we do get blindsided sometimes with a lot of complaining, and we're like, I didn't even know the project was coming up. But you bring up a good point, and I might want to work with you in the future about expanding this in some different ways, because I'm getting tons of phone calls and complaints, and it would be better, I can call the state people, of course we can call them, but it'd be better if I'd gotten some notice right in the beginning and a scope and a reminder of what's going on there.
Yes. That's
So I
right.
think you're onto something. All right, thank you.
Thank you.
Good afternoon. What is a type 2 or type 3 project?
Thank you, Senator, for the question. So basically, they're 1, 2, and 3. We were not looking to get at those smaller projects. That's why to the Senator, I wasn't talking about necessarily like driveways or things like that. So type 2, think Walmart. Type 3, think stuff even bigger than Walmart's. Could be a really large shopping mall. Could be a very large residential community. I have some, say, in my district where I've got one that's got 3,000 units going in. You know, you're also not talking about smaller residential communities. We're talking big trip generators.
Gotcha. So when we're talking about someone that's submitting an application, it's simply we're talking about developers.
Yes, we're talking about whoever is developing the project. So it could be Walmart, could be whoever is developing that site for Walmart, whoever is the developer on that project.
Thank you.
Thank you, Senator.
Senator, if you go to the fiscal note on this bill, there's actually embedded link, like a hot link inside, and it'll take you to another page that has a description of what type 1, type 2, type 3 projects are. It's pretty, I've never seen that before in the fiscal note. That's kind of cool. Yeah. But anyway, fantastic bill. I love this bill. So it's great. Yeah. Thank you for bringing us, Bill. Thank you for your patience. And seeing no further questions, that will end the hearing for House Bill 1508.
Thank you, Mr. Chair.
Okay, thanks a lot.
Thank you.
All right. We will now move on to Delegate Terrassa. You're here with House Bill 1132. And you do have one witness signed up?
I do. Can you come on in here? Thank you. All right. Good afternoon. Hope you love this bill, too. Good afternoon, Chair Smith, Vice Chair Waldstreicher, and members of the esteemed Judicial Proceedings Committee. For the record, I'm Delegate Jen Terrassa, and here to present House Bill 1132, Keeping Affordable Housing Affordable Act, which will help address the cost of housing in some of our most affordable for-sale homes in Maryland, which are condominiums and townhouses. This issue came to my attention from realtors who strongly support the bill and are here in support. This bill passed the House unanimously, 130-0. And prior to its passage, we accepted Republican amendments. The problem is that condominiums and townhouses are often the first point of entry into the real estate market for first-time buyers, young families, and Marylanders seeking attainable homeownership. However, escalating condominium and homeowners association resale fees are making these homes more expensive and in some cases harder to purchase than they need to be. So you probably already know what a resale package is, but just in case, it's the information that a seller is required to give a buyer when selling a condo or townhouse in a HOA or condo association. And it contains important information about the financial standing and about the home being purchased and the community. It includes most of the governing documents, but also some other information.
this is usually handled by your realtor. So if you bought or sold a home in an HOA or condo association recently, you may not even know this or realize this was a thing. However, a couple years ago, I sold my home for sale by owner, which gave me a unique insight into this. Realtors have been telling me for years that these fees have become excessive, and you would think it'd be simple, right? You call the HOA, and they send you a copy of the documents, and then you send them on to your buyer. Maybe charge a few bucks for finding them and hitting send on the computer. But what happens instead is that resale packages are often produced by community management companies who sometimes contract out to third-party processing companies who put together the resale packages. And it's really become sort of a money-making enterprise in some ways. You know, we were told by the community managers that sometimes this is used to supplement what it costs them to manage the communities in the first place. So in my case, just to give you some idea of what costs we're talking about, in my case, I was charged $295 plus a $10 credit, credit surcharge. But then I was also told there was a $100 fee if I wanted the documents delivered within 22 days. But I only had 20 days, so I theoretically had to pay that fee. I didn't have to because I had a cooperative buyer, but that would have been another $100. At any rate, when we went to settlement, I was surprised again. It turns out there was another $150 for them to confirm that this is still current information. All these fees can really add up to the hundreds of dollars. Mine was $455, could have been $555, and it's gone up since then. My understanding is they're charging somewhere between $500 and $1,000 today. So what my bill does is address this by modernizing and harmonizing Maryland resale disclosure laws under Condominium Association Homeowners Association Act, and it clarifies the resale package fees. In the years since the current fee caps were established, technology has really helped bring the cost down of delivering this package. In fact, most of them, or a good majority of them, are just, somebody hits send and they send you a packet online. It's not somebody, hand delivering them or going from place to place to get the information. So this bill prevents excessive and duplicative charges, which increase the closing costs. And it updates the timelines and notice requirements to reflect modern practice. It conforms inconsistent provisions between the Condo Act and the HOA Act, creating clearer, more predictable standards for those involved. And I just want to say a quick word about, you got comment from CAI. And I first want to note that for years now, I've been working on this bill, and we've tried to get CAI to the table to have a conversation about this, and we've certainly had conversations, but they refused to compromise with us on, or any of the advocates, claiming that the national organization dictates their position, and therefore they can't negotiate on any of the items in the bill. Well, I would say the national organization shouldn't dictate Maryland policy, and I'm sorry that they can't negotiate, but that makes it impossible to have any conversation or make any changes in this. So one of the things I just want to mention is that they claim that this doesn't affect affordability, and that other folks are charging various amounts for their role in the resale in the selling market. But what I would say is, unlike with a realtor, a lender, a title company, when you're trying to get a resale package, you don't have choice of where to go. It's a one-stop shop. You have to go to your HOA, and you have to use the company, and you have to take the fees they're charging. If it was a title company or lender, you have a choice. You can say, I don't like what this lender or this title company is doing, and you can go to another one. So I just wanted to point that out, and it really does impact, the bottom line in terms of the closing cost. And I'm happy to address any of the other claims that they have. They've made, if anybody has questions about that. They said that this would increase the costs, or the fees that were agreed to in 2016. But one of the things I'd say is those costs have come down. And the other thing that I would say is that in the meantime, they've charged all these additional fees. So there was some agreement, I guess, some years ago, maybe more than 10 years ago, or around 10 years ago at this time, that $250 would be charged. But since then, they've started adding on all these other fees. So this really brings it back down to the $250 to charge for those. I would say I am in two homeowners associations. One of them is the Columbia Association, and one of them is my local, or was before I sold, my local townhouse association. And when I went over to Columbia Association to get the information, they charged me $25. They went to the back, they made some copies of documents, and they handed them to me. But again, when I went to my HOA, I was paying almost $500 or $450. So with that, I'm going to ask for a favorable report and happy to answer any questions you might have. Just a reminder, it passed the House unanimously, and I hope I can have your support as well.
Thank you, Mr. Chair, Mr. Vice Chair, members of the committee. Lisa May with Maryland Realtors, and we thank Delegate Terrassa for bringing this bill. While this is not a cross-file bill, it may seem familiar to you. There was a similar bill sponsored by the Vice Chair back in 2024 addressing these same issues. And it's back again because the issue of condo and HOA resale is a very frustrating one for our members, certainly, but more importantly, for home buyers and sellers. Between the two acts, there are different timelines and different disclosures. And this bill at least begins the process of trying to bring those together. And that was a recommendation of a state task force on common interest communities, a report that came out 20 years ago, and we are still not bringing these two acts together. We still have many, many places where the acts are not in alignment with each other. And as Delegate Terrassa mentioned, this also adjusts the resale timelines and fees to reflect more modern practices. Online delivery versus flipping through filing cabinets, going to copy machines, going to FedEx or Kinko's and FedExing this out in hard copy to prospective buyers. But she is also trying to strike a balance here to ensure that the association's work, which is related to the resale process, those costs can still be recovered, but that those buyers and sellers are not subsidizing the ongoing administration of the association. And this is really important because, as she mentioned, a single property can be subject to several different associations, 2, possibly 3, each with their own resale packages, their own requests, their own itemized list of fees, and those can really add up for a first-time or lower income buyer. So for those reasons, we would ask for your favorable report. Thank you.
Delegate, good to see you again.
Good to see you.
I'm intrigued by the bill, and I appreciate you bringing it, but I've represented a lot of HOAs. I've just been involved in litigation, and I can tell you, even with the modern invention of the computer and email, it is shocking how complex it can be to get these resale packages together because there are lots of subsequent meetings, subsequent documents. It takes a lot of effort. Sometimes they're simple, I totally agree with you, but other times they're quite complex. And I don't know if picking one particular number, and applying it without some more thought would work. But what I really do applaud and want to figure out is your witness or the realtors brought up that there had been a task force. My first thought was, let's get back to work and not do just one bill at a time, but let's try to align this and try to get all the stakeholders in the room and figure out what is fair to charge in general, with some known exceptions, which as a person in this area who does this, I can think of a number of areas in which your capped fee is not going to capture the amount of time and cost and complexity that it requires a lawyer to be involved in, because I've been involved in them. And if you make a mistake, you can have litigation that is unbelievably complex. So I like the idea of working on this and getting through it, but I feel like we've got to bring everybody together. Maybe 20 years is making it dated. I don't know. I'd love to hear from your witness. But I like what you want to do. I'm just not sure we shouldn't do a little bit more comprehensively and get everybody back in a room to make sure we align these things. And when we start, if we're going to cap fees, make sure we cap them at the right amount and or have a number of clear exceptions or ways in which we can capture the nuances that might not be obvious to you, but to someone who does this, there's a lot of situations that are not captured in your bill, with all due respect.
And I appreciate that comment, Senator. And what I would say is that I support us having task force on looking at HOA and condo association, everything related to that. You had Delegate Holmes here yesterday on a number of issues. But I think in the meantime, I think the legislature has a big emphasis on affordability. And in the meantime, these fees have really gone up, and I don't see anybody justifying $1,000 or $600 for these packets. And in fact, the $250, which essentially my fees add up to, was what was agreed on by the Community Association Institute. And they're not arguing that those are that wasn't acceptable. They just want to be able to charge all these other fees on top of it.
Well, I got to read through it.
Yeah, no, and I appreciate that.
It's a big, complicated issue, I think. And
Right.
I'm so glad you're working on it.
Yeah, and we've worked on it for quite a few.
Excellent. Seeing no further questions, thank you very much. All right. Thanks. All right, we're going to go on. That's right. So that'll conclude the testimony for the proponents of the bill. We do have a witness sign up in opposition with Ms. Kent, Cynthia Kent. Excuse me, Ms. Kent, sorry, hold on 1 second. Ms. Kent, your mic is on, but it's not on. So can we turn it off and then on one more time? There you go. All right, there you go.
Okay. This is a small resale package. This is a large resale package, both for condominiums. We have one size fits all in this bill, but we have small, medium, and large condominiums. I have with me today Marie Fowler, who is a manager, who is ultimately very responsible for this package. Myself, I offer you as technical advisor. I have taught the resale disclosure laws to the realtors for the last 15 years, 4 times a year. They walk into the class saying these fees are outrageous. They walk out of the class going, I had no idea there was this much work involved. There are 14 disclosures by the condominium. There are 6 or so disclosures by the homeowners association. There's a risk in providing this package because if this package is not accurate, you can be sued for misrepresentation or omission. Some are done in-house by self-managed associations. I've done them before, how to manage self-managed HOA. Some are done in-house by management. And yes, they deserve to be paid for the work that they do. It is not a touch of the button because, as Marie has informed me, she's outlined 14 steps by 4 to 6 different people to give the information to a provider who will then package it and give it to the realtors. The provider can be sued for misrepresentation. There was a case that was over $1 million in risk to the management company. And for $150, you can't cover that risk. So yes, they deserve to be paid for the work that they do. I have friends who are realtors. I have friends who are title companies. Their fees are very high. I'm not asking them not to be paid for the work that they do. But I know that these managers do a lot of work, and these were agreed upon a decade ago, and everybody has abided by them. Thank you for your attention.
Excellent.
Unfavorable report.
Thank you very much, Ms. Kent. Thank you for your patience. Senator Love has a question.
Thank you, Mr. Chair. Ms. Kent, did you meet with the sponsor, and if not, why not?
We did. We actually had a 45-minute conversation. And in that conversation, I was on the call, as well as Igor Konev, who is the chair of the Legislative Action Committee for CAI. And we tried to explain to Delegate Terrassa how much work is involved in these packages. Mr. Konev indicated that he has a condo that has 21 bank accounts. And that is because they are now amassing the reserves. And he has to put together that information in this resale package because a lot of it is financial. And so we did try to explain to Delegate Terrassa that these caps were agreed upon a decade ago. Everybody is working very hard to abide by them, but a condominium that's very large, you may lose money on. A condominium that's very small, you may be able to do it within the cap.
Did you have any, I'm sorry, Mr. Chair, may I? Did you have any discussions with the sponsor about what might be a reasonable fee or a reasonable cap? Or did you just tell her what you just told us?
Again, it was discussed over a decade ago, and everybody is abiding by those amounts.
That's not what my question was.
Yes,
My question was, did you talk to the sponsor about what might be reasonable fees today? Things are different today than they were 10 years ago.
And in fact, the Department of Housing and Community Development has increased that cap from its original $250 to $311.24 in accordance with the CPI. Costs have gone up. Construction costs have gone up 30%. Services have gone up more than 30%. Insurance premiums have gone up 150%. Everybody's trying to put the reserves away. And if this doesn't, if the management company is not allowed to provide this service at a reasonable cost, which that cap is, then they will say, we're not going to provide this service.
Okay. The answer to my question is no then. Thank you, Mr. Chair.
Yes, we did. I disagree. We talked about how many hours it might take to do this. We talked about the steps that it takes to do this. The answer to your question is yes. Did we talk about those things? Leave the caps where they are.
Thank you, Mr. Chair. So I think this is our last bill hearing. So, okay, that's good. This was the end. So here's my question. If I were going to list my condo, I would request from the condo association all these documents in advance and give them to the realtor, give them to the listing broker, so when a contract of sale is entered into, the broker could provide them to the purchaser. Wouldn't that be the logical way to do it? And you wouldn't have to scramble so much after the contract of sale has been entered into.
That is one way of doing it, but this resale package is as of a point in time.
Aren't most of these documents photocopies?
No. This is a resale package as of a point of time. So it calls for the most recently prepared budget. It calls for the most recently prepared financials. And let's say, for example, that you're selling in September or October. That's a time when the condominiums and HOAs develop their budgets. And they actually might have two budgets. They might have the budget for 2026. They might have the budget for 2027 at that point in time. At that point in time, they may have changed their insurance premiums. Their insurance policy. So they might have a different insurance policy from the time that you got it. They might have a violation that didn't exist at the time that you got it.
Okay.
I
gather what we don't have to go into great detail. So you're saying some of these numbers are time sensitive?
Very, very time sensitive.
It seems to me maybe we should have like a forgiveness clause that so long as the information was accurate as of the date on the document, the purchaser could rely on that information as accurate at that time. And if the purchaser really wants to get updated information, they'd have to come back and pay a higher fee or pay an additional fee.
And it might be, but the way it is currently written, and again, I'll go back to what Ms. James has said, maybe we can find ways to make it more amenable so that things can be the balance sheets or the financials as of the last month, at the end of the last month. Instead, what we have, let me give you an example. We had 2 winter storms. Everybody's budget is blown. We want to inform that buyer that those snow and ice removal costs are coming, because they might decide they don't want to be subject to a special assessment, which might be surely coming when your costs were $125,000 and you only budgeted $65,000.
I see.
That's what happens in condominiums.
Great.
That's what happens in HOAs.
Thank you for your answers.
All right, seeing no further questions, thank you very much, Ms. Kent.
Thank you, committee
With
members.
that'll conclude the hearing for House Bill 1132. We're now going to move on to our final bill of the day and our final bill of the session and the final bill of the term and the final bill hearing for Senator West. Oh. So we're going to go with Delegate Hill with House Bill 915. And Ms. Patel is going to be presenting for Delegate Hill.
Good afternoon, Chair Smith, Vice Chair Stryker, and members of the Judicial Proceedings Committee. My name is Juhi Patel. I'm a current graduate student in health policy at Johns Hopkins University and have the pleasure of serving as an intern for Delegate Terry Hill this session. I'm here on behalf of Delegate Hill to present House Bill 915, Work Group on Aging Out of Foster Care. House Bill 915 establishes a work group to identify resources that currently exist for youth transitioning out of care and how those resources are actually working. This work group brings together relevant state agency leaders, advocacy groups, alongside 15 young people between the ages of 18 and 25 who have aged out of or are currently aging out of foster care, because no one understands these gaps better than those who have lived them. It will work to identify the types of resources currently available, their effectiveness, and those worth further investing into. A report back with recommendations to guide our efforts in this area will be due by June 2027, which would aim to successfully identify gaps in youths transitioning out of foster care and how we can continue to do better as in Maryland. As it passed the House 136-1, the bill includes a $2,000 stipend for these youths as we recognize the importance of compensating young people for their time. And every year, we know that thousands of young people across this country age out of the foster care system. Unfortunately, most of these youths will remain in foster care until they age out at 21. These formerly fostered adults face statistically disproportionate challenges with mental health, substance use, unemployment, or cycling through the corrections or homeless systems. While we acknowledge these outcomes, we lack a full understanding of why these challenges persist and which supports are most effective in helping youth transition successfully into adulthood. As a young person myself, navigating early adulthood would not be possible without the resources and support I am fortunate enough to be simply born into. I do not often acknowledge the natural support that I have that these youths lack, including how to get your first apartment or do your taxes. And these young Marylanders deserve that same foundation, better preparation, stronger support, and access to the resources they need to thrive. And that is exactly what this bill seeks to establish. So I urge a favorable report on HB 915.
All right, thank you, Ms. Patel. Questions from the committee? Excellent job. Thank you very much.
Thank you.
So with that will conclude our hearings for the day, the week, and the session. We'll see you all on Monday.
You said for the session?
Yeah, we're done.
No more hearings?
So we'll be doing more voting.
We're doing more voting.
But we're not hearing any more of the multiple bills?